Right, we are on the record. First matter is Amex versus Jason Campbell Everett, case number 243818GC. Is counsel here for the plaintiff?
Yes, Your Honor. Dreek Gertzberg, P80136, appearing on behalf of Plaintiff American Express.
Good morning. And sir, you are Jason Everett?
Yes, sir. I'm here on special appearance. I am
What?
the registered agent for the registered.
I'm sorry, you're not Jason Everett?
Yes, I am Jason Everett on special
Okay.
appearance.
All right. So, Ms. Gertzberg, this is a claim of failure to pay a credit card debt.
That is correct, Your Honor.
And I've read the answer that you filed, Mr. Everett, and you deny that there's a contract and claim that there's a statute of frauds problem on the plaintiff's complaint. Is that right?
That's correct.
Okay. All right. So we're going to allow discovery, which is a process in a civil lawsuit where each side can request documentation from the other side with regard to their claim. I'm going to allow written discovery only. And discovery will be open for 90 days. So that will take us to February 6th of 2025.
Your Honor,
Yes.
as attached to the defendant's answer were a number of what appeared to be discovery requests, a number of written requests for, I guess I would say, similar to interrogatories and requests for productions of documents, but
Okay, well then I
they
guess I
were,
would suggest that your client should answer them.
well, they were not presented in the appropriate manner. They are not in conformity with the
Well, counsel, you
the
can
court
either have
rules.
your
Before the judge even finishes calling the case, you can already tell exactly where this is going. This is one of those hearings where confidence far exceeds competence, and the defendant believes that saying the right magic words will somehow erase a very real credit card balance. What we're about to watch is a sovereign citizen adjacent strategy play out in real time: deny the contract, deny the identity, deny jurisdiction, and hope the court gets tired and gives up. Spoiler alert, that never works. Especially not in a civil debt case where the defendant openly admits to using the credit card. This case is particularly entertaining because it's not some complex legal puzzle. It's simple. American Express says, you used the card and didn't pay. The defendant says, I'm here on special appearance, there's no contract, and I don't recognize reality. And what makes this even better is the judge. Calm. Patient. Clear.
We'll take them up. The purpose of discovery is to allow each side to discover what the other side's claim is. And so if your objections are just going to be based on form only, I'm probably not going to be terribly concerned about the form, particularly where the defendant is unrepresented in the case. If there are some substantive issues, then you'll need to brief the issues and bring them before the court with the proper motion. So witnesses need to be exchanged by February 6th of 2025. Exhibits need to be exchanged by February 6th, 2025. And motions may be filed and heard as permitted by the court rules. We will set this matter for a non-jury trial. That'll be a Friday. We'll need some date after March, or in March or later.
March 14th,
March 14th
9:30.
at 9:30, and that'll be in person here at the courthouse.
I just can't have my client have to respond
Hang
to
on just a second,
50
counsel.
interrogatories.
Just a second, counsel.
March 14th.
I'm sorry, counsel, did you have something you wanted to say to the court?
I can't, in good faith, have my client answer 50 interrogatories.
Well, I guess, counsel, I think I've tried to direct you as to what your ability to respond to those are. So I'm not going to practice law for you, Ms. Gertzberg. You'll need to do it for yourself. So we will schedule the matter for a non-jury trial in person, March 14th at 9:30. And is there anything else for the plaintiff?
No, Your Honor, thank you.
Okay, anything else for the defense?
Judge, I'm just curious on why this counsel is here when I have another counsel on my paperwork.
Okay, Ms. Gertzberg, can you explain your involvement in this case?
We work at the same firm. The appearance of counsel of one member of a firm is the appearance of all members of the firm.
All right, so I think that that
Fair
is
enough.
pretty common response, and I think that is acceptable, so.
And right here we get the first red flag. The defendant immediately tries to split himself into multiple fictional versions, the registered agent, the registered entity, and the real person who somehow isn't really there. This is a classic tactic pulled straight from sovereign citizen playbooks. Courts don't recognize this distinction. If your name is on the case caption and you're standing in the courtroom answering questions, you are the defendant. There is no legal loophole that allows someone to show up physically while pretending the legal obligations belong to a separate imaginary entity. Notice how the judge doesn't argue philosophy. He doesn't debate metaphysics. He simply clarifies identity and moves on. That's intentional. Judges don't indulge pseudo-legal theories because engaging with them only gives them oxygen.
Plaintiff's motion for summary disposition. Mr. Tetro, you may proceed.
Thank you, Your Honor. Yeah, this is plaintiff's motion for summary disposition. It's being brought pursuant to MCR 2.116 C9 and C10. C9 is failure to state a valid defense, and C10 is no genuine issue as to any material fact. Excuse me. The evidence that's offered in support of plaintiff's motion establishes that Mr. Everett opened a credit account with plaintiff in November 2016. He used his card to make numerous purchases over the next few years. He accrued a balance which went unpaid. The account went into default, and now the plaintiff brings this count of breach of contract to recover the unpaid balance on the account.
Okay. There was a response filed to the motion by Mr. Everett. Did you receive the response?
I don't believe so.
Mr. Everett, did you file the response with the plaintiff's counsel?
Yes, sir. I have tracking number. I can track it.
I'm sorry, you have what?
I have a tracking number for the mailing. I can track it.
This was filed back on March 24th, is that right?
Yes, it was sent out the same day, USPS.
What's the title of the document?
Notice of judgment to dismiss for lack of contract and jurisdiction.
It's notice of motion to dismiss for lack of contract and jurisdiction.
Okay. Does it also say high priority judicial declaration?
Yes, it does.
Okay, we did receive that.
Okay, would you like to respond to it?
Yeah. So the filing that Mr. Everett has filed, now it's my understanding that this is a response to the motion for summary disposition. It doesn't really address too much of what's in the actual motion for summary disposition. It does talk a lot about the UCC and Fair Debt Collections Practices Act. most of what the plaintiff talks about, or excuse me, most of what the defendant talks about in his response is not applicable to this case. UCC doesn't apply to consumer debt. The Fair Debt Collections Practice Act doesn't apply to the originators of the debt. Yeah, most of it's not addressed to the motion. So, and also it doesn't offer any affirmative or documentary evidence to contradict that which is offered in support of plaintiff's motion. So I think at least as it stands for the
This is where the defendant makes his central claim, that there is no contract and that the statute of fraud somehow voids the debt. The problem? Credit card contracts don't require a handwritten signature in the way he's implying. Courts have repeatedly held that use of the card, acceptance of benefits, and payment history establish a valid agreement, and here's the irony, denying the contract while simultaneously using the card is legally contradictory. You can't accept the benefits of an agreement and then deny its existence when the bill shows up. That's not how contract law works. What's interesting is that the judge doesn't argue this point yet. Instead, he moves directly to discovery. That's strategic. He's saying, let's get the documents on the table, and reality will sort this out.
Position with regard to the existence of a contract. You said this is a breach of contract complaint.
Yep, there's a contract. There was a contract attached to the complaint that was filed. There's a contract attached to this motion.
Those were signed by both parties?
I don't believe they were signed by any party, but there's no requirement for a signed writing. Statute of fraud doesn't apply to credit accounts. The terms of the agreement that are attached, both the complaint and the motion, are clear, and the terms of which are clear and unambiguous, that use of the account is acceptance of all the terms of the agreement.
Okay. I'm just looking at for the complaint in this manner. It's strictly a breach of contract complaint. Is that right?
Yes.
Okay. It's not an open account claim.
No, I don't believe so. I think it was just one count for breach of contract.
Okay, Mr. Everett, response?
I wholly disagree based on all of my research and based on all of the listings from UCC, listings from the Internal Revenue Code, subsection 166 on charge-off reporting. My Exhibit A was proof that the account was charged off. That basically prevents financial institutions from profiting from a debt that was already satisfied through other means, which means if it was charged off, they got a tax credit for it. I also listed in here that if they cannot enforce if they've already received benefit. That's just one of many here, sir, that are legitimate and are applicable to consumer accounts and consumer law. Statute of frauds, UCC 2201 requires that a contract for the sale of goods for the price of more than $500 be in writing and signed by the party whom enforcement is sought. They have no signatures. They have no electronic signatures. They have no wet signatures. There's quite a bit of things here, sir, that are not aligning with what the plaintiff is claiming.
Well, let me ask you this. I mean, you did have a credit card that was from American Express. Is that right?
Yes, sir.
And looks like you used that credit card for charges at numerous local locations, including Granger Waste Services, Meyer, Capital City Grower Supply, Chipotle. And they haven't been paid for those charges. Is that right?
Well, sir, my use of the without prejudice notarized UCC 1308 in connection with my signature indicates that I reserve my common law right not to be compelled to perform under any contract that I did not enter into knowingly, voluntarily, and intentionally. And I do not accept the liability associated with the compelled benefit of any unrevealed contract or
most important moments in the hearing, especially for viewers who don't follow civil litigation closely. Discovery is not punishment. It's transparency. It allows both sides to see the evidence, documents, and claims before trial. The judge is being exceptionally fair here. He limits discovery to written requests, gives a clear timeline, and lays out deadlines in plain language. There's no trick. No abush. No procedural unfairness. This is also where sovereign-style arguments usually start to unravel. Once documents are exchanged, account statements, usage records, payment history, abstract theories don't hold up. Paper beats philosophy every time. The judge is giving the defendant exactly what he claims to want: process. And ironically, that's what will ultimately defeat him.
Use of the account binds him to the terms of the agreement. He's just admitted that he used the account, so I think the facts are kind of undisputed at this point.
Okay. Well, I do not find that there is a genuine issue of material fact. I find that the defendant did use his American Express card, did run up charges and receive a material benefit by using it, and that obviously he made some payments on the account, which acknowledged that there was an agreement that if he used it, he would pay, and then he stopped paying at a certain point in time and went into default. The court does find that his use of the credit card and acceptance of the benefit of using that credit card to make purchases does constitute a binding agreement, and therefore I do find that plaintiff is entitled to summary disposition of this claim. The various laws that were cited by Mr. Everett are not applicable, and so that's the ruling of the court. I will sign an order. Was there an order, a judgment submitted, Mr. Tetro, with the?
Yes, Your Honor. If you have the motion packet, it should be the very last 2 pages of that whole motion packet. The last 2 pages of the exhibit should be a proposed order, or excuse me, proposed judgment.
It's about a 300-page motion packet, so it's a little bit difficult to.
Should be the very last page.
Okay. Okay. All right. That's all for the record in this matter. I'll sign the order and send it to the parties.
Thank you, Judge.
This exchange is quietly devastating for the plaintiff's counsel, and revealing for the defendant. The attorney complains about the volume and form of interrogatories, but the judge shuts that down immediately. He makes it clear, substance matters more than formatting, especially when one party is unrepresented. That comment about not being terribly concerned about form is a polite judicial way of saying, stop nitpicking and answer the questions. Judges care about fairness, not paperwork games. This also undercuts one of the defendant's implied narratives, that the system is stacked against him. The judge is bending over backwards to ensure procedural fairness. Clips, clips. This is where the judge firmly reasserts control of the courtroom. When counsel protests again, the judge refuses to practice law for her, a subtle reminder that attorneys are expected to know procedure. This moment reinforces something important: courts are not chaotic.